Is the gentleman opposed to the motion?
Yes, Madam Speaker.
The gentleman's recognized for 5 minutes.
Madam Speaker, first I will acknowledge, and the gentleman from Delaware was quite civil, and I will acknowledge that this is a moderate approach. I only hope, given the current situation, he's not in political trouble for taking a moderate approach in his party, but that's a matter for another day. The issue for me here is the extent to which many of my colleagues on the other side are engaged in an on-again, off-again love affair with the Federal Reserve. The Federal Reserve has often been the object of their scorn, but when it comes to consumer protection, the Federal Reserve is sometimes a convenient bulwark against that. For example, when the committee passed the Consumer Financial Protection Agency, which transfers more power from the Federal Reserve than any other group of federal entities, many of my Republican colleagues ran to the defense of the Federal Reserve by quoting the chairman of the Federal Reserve as saying, "Don't take this away from us." We have this on-again, off-again. What this bill does is really quite remarkable. It empowers the Federal Reserve to cancel an act of Congress. We are hoping to get this bill passed, and there was some concern in the Senate from the Senate chairman, and thanks to the amendment that was offered by the gentleman from New York, Ms. McCarthy, and the gentlewoman from Colorado, Ms. Markey, we've accommodated his concerns. We think we have a workable proposal here. What the recommit says, if the bill passes the House and passes the Senate and is signed by the President, we will then await the permission of the Federal Reserve Board of Governors to implement it. And if they say it's not feasible, then the bill dies. In fact, they did write us a letter and say that if they had to do it by December 1st, we wrote to them a couple weeks ago, here is this problem, that they wouldn't be able to get full comment. But they also note the Administrative Procedures Act does provide a good cause exception when the notice and comment period would be impractical, unnecessary, or contrary to the public interest. And so what they say is, if the effective date for these provisions were moved to December 1st, the board would have to issue final regulations without waiting for comments. Well, but the point is that they've had a lot of time for comments. The Federal Reserve proposed this earlier after the gentleman from New York, Ms. Maloney, initiated it. The President signed the bill, the underlying bill, the effective date of which we are trying to advance, on May 22nd. They've had, 5.5 months to study it? This is not the most complicated thing in the world. And by the way, if this was so complicated to figure out, how do the banks manage to be able to increase so quickly? Apparently the banks have this problem. When it comes to implementing a law, they're working with typewriters. When it comes to raising your rates retroactively, remember, the biggest single part of this bill is that it says if you got a credit card and abiding by the terms of that credit card, you bought things and you charged them at the interest rate you were told would apply, and you made every payment you were legally obligated to make, they can retroactively raise your rates. That's the biggest single thing we stop. And I don't see why it's going to take them 8 or 9 or 10 months or a year to figure it out. The gentleman's right. We did have a compromise. I thought February was too much time in the first place. But here's the basic point. Several of us said, okay, we will reluctantly agree to February for a bill that passed in May to do something that's not that complicated. But if you abuse it, if you use the time to raise rates and then blame us for it, adding insult to injury, then we are going to speed it up. So I think our credibility is at issue here. We, in good faith, said take some time to implement it, May 22nd to February. Many of you have heard what they did was to speed this up. There was an element of unfairness here, and yes, the Federal Reserve will have to forego some public comments. I think I would say to people, you know, we have till December 1st. If you're out there and you think the Federal Reserve was going to listen to you, Madam Speaker, let me violate the rule, please, and address people who aren't here. If you're listening and you really need to talk to the Federal Reserve, write them a letter, send them an email, call them up. You don't have to wait, so we can get your comments in now and we can go into effect by December 1st. And we certainly should never set the precedent that any agency, and certainly not the Federal Reserve, which has become so controversial, should be given the power to suspend an act of Congress before it goes into effect. That is what this does. It says that we will pass this law, but unless it is certified as feasible by the Federal Reserve, it doesn't go into effect. I have a lot of respect for the Federal Reserve, but they're not in charge of what we think is feasible. They're not in charge of telling us that we have to wait more for public comments when our constituents, we believe, are being mistreated. So I hope the recommit is defeated.
Gentleman's time's expired. Without objection, the previous question